Hopefully, there we go. And we'll go back to share screen. Should take us right back in Dotloop. Can you see that okay?
Yes, yep.
Okay. So this I'm going to use as an example. This was a house that Candace wrote an offer on before the end of the year and didn't end up going through. It was actually dead deal due to financing. Last time around, we got through the purchase agreement. And so what I want to do today is kind of cover the additional docs. So if we kind of recap where we were last week, we did agency disclosure, buyer agency form, and the purchase agreement. So now those are kind of the main portions of that vehicle that we use to get a deal done. But there's internal forms, there's other forms that we need to be aware of. So you can see here her loop is actually populated with some things. And then I'll show you where to find other docs that we need too. So in your initial loop, you're populated with some of the standard stuff. Moving down from the purchase agreement, she added, and you'd be able to pull this off of the MLS, she added the seller's disclosure statement, which if they haven't filled this out, you'd mark that you haven't received it. But typically now the board requires that these be posted online and available to at least the agent's side of the real estate board or the MLS. So this was filled out. You can see here, they checked some boxes, microwave, yes, it worked. They marked here that alarm system didn't work, nor did the garage door opener. I'm questioning whether or not those should have been not available instead of no, they don't work. But typically that's the one mistake sellers make when they fill these out is they just mark no if there isn't one. And so it looks like they kind of caught that over here maybe too and amended that by marking not available. So it'll go on to say, has the basement had water? This one said no. Fiberglass insulation in the walls, cellulose in the attic, pretty typical for an 18-year-old house, which I think this was. Roof was original. Looks like it had a new septic system. Propane heating system was new in 2016. So obviously you want to go through these with your buyers and just explain to them what all this means. A lot of these other questions on the backside, environmental problems, flood insurance, they've marked no for flood insurance, mineral rights. Most people don't know whether they have mineral rights. The one thing you want to advise your clients on is unknown is different than no. And the one time I went to court with a client was my sister-in-law. She bought a house in Grand Haven and there was a pipe sticking up out of the backyard. We didn't see it. It was dead of winter. It was buried in snow. And come spring, of course, it's Grand Haven. Everybody knows each other. She called the seller and said, "Hey, what's this pipe coming out of the ground?" "Oh, that's an old oil tank." And their seller's disclosure statement said no, that there weren't any. And so she took them to small claims court. We went there, and of course, they denied everything. "Oh, we didn't know what was back there. We never said that." And it came down to what the magistrate, we weren't even in front of a judge. The magistrate looks at it and says, "Well, you marked here that no, which means you have specific knowledge that there are no tanks in the background or in the backyard." And so my sister-in-law won her court case and got like $3,500 to pull an oil tank out of the backyard. So just little tips there. And again, we'll cover these from the seller's perspective when we do listing docs too, but
unless you're sure, put unknown.
Correct. Yep. And again, I mean, from the buyer's perspective, if it's marked no, then you're going to explain to them that they should have specific knowledge that no means that it doesn't exist. So not that they don't know.
So you avoided a huge crisis. Damn.
Then along with that, you should have LeadBased paint in here. I didn't see one. This home was built after 1978, so it wasn't really pertinent, other than they should have signed a form saying that they knew the house was built after 1978. And again, we'll get into that on the listing side too. But if the home was built prior to 78, you do need that LeadBased paint form in there too. And I'll show you where to find that if it's not in the listing docs. So EMD is something that, this is probably a copy of a check for security purposes. I'm not going to pull up copy of that and as a recording that other people can see online. So we're going to let that go. The septic disclosure is, I think, something specific to the board down there. This is Covert, Michigan. This isn't one of our board forms, but they have a separate form for septic disclosure. And I don't know if you guys caught my video that I did with the explanation of well and septic changes on the new purchase agreement that came out just this past week, but not every municipality does everything the same as Kent County. And so just be aware of that. And if you get into an area that you're unfamiliar with, make sure you understand, at least from your broker, the county health department, and or the other agent as a last resort, what protocol is there. So because we work in a vastly diverse world now amongst counties when it comes to well and septic, and we need to be prepared for that. But
And can I ask, where did you put that video, or where?
there's a link to, it's a YouTube link. I put it on the Facebook page in there, and then we'll send out an email too with that, a company-wide email shortly on that. So their pre-approval letter is in here. This is always something that should be submitted with an offer. That or proof of cash funds. In today's competitive environment, if you're not sending one of those two things, probably not going to get a hard look if there's multiple offers. So just make sure that you're getting those pre-approvals in advance of taking the buyers out to get to look at homes. So
That pre-approval letter, like, when you have a pre-approval letter, that's really the only thing that tells everyone that you're serious, you have the funds potentially available to buy, right? That's the only thing you need as well.
yeah, well, that, and if you're writing appraisal gap coverage, and we'll get into some of those things later, if you're writing an appraisal gap coverage into the purchase agreement and you're offering to cover $10,000, $20,000, $30,000 additional aside from your down payment, I would make sure that the other agent knows in some manner or another they have those funds available too. And that could be a 401k statement that they borrow against. That could be, cash in the bank.
Okay.
Something to that extent, say, hey, look, if we're going to offer 20,000 extra in the event of appraisal shortfall, then make sure that we've got those funds on hand. So
when you're dealing with like a cash buyer, then you're just asking for like a bank statement to prove that you have the funds available to do it.
Yeah. And you can do that a couple different ways: a letter from a banker verifying it, or a bank statement. Again, what I like to do with bank statements is make sure that we're redacting, pertinent information.
Right. Okay.
Things like account numbers, home addresses, anything on there, name, last 4 digits, the account number, and the balance are really what you need on there. So, but Sierra, I see you joined us. Are you able to hear me okay? I thought,
You might be muted.
yeah, I don't see her in here, and I thought I had.
Sorry, yeah, I'm in here. I'm sorry.
Okay, yeah, no worries. I just want to make sure you were in, because we're sharing. I'm doing the screen share. I want to make sure you can see that for one, and two, that you were in, because I didn't want to kick you out. So
Yeah, thank you for checking.
no worries. So just to kind of catch you up, what we've talked about so far is really just the seller's disclosure statement being part of the buyer contract, and John had a couple questions on some things, and then moving along on some of the other documents here, you're going to see that we've got this wire fraud warning document, wiring scam, we call it. And again, wiring fraud, wire transfer fraud is such a rampant thing in our industry. I'm going to shut this door. Hang on a second. It's such a rampant thing in our industry that we have to take preventative action to make sure that our client money is safe. And so gives them specific things. Now we also have, I've got a recording of a wire transfer fraud prevention Con Ed class that we put on a few months ago. I've got to get the recording of it, and we're going to continue to make that available too. So, you know, just how real and serious this is, and things that you don't even think about, like on, you know, people that can infiltrate your Gmail. There's stories of people getting catfished on Facebook, becoming friends with people overseas, and then going, oh, I got this check, I need to deposit, and it's stolen money. The next thing you know, there's a teacher from Waterloo, Iowa that thinks she's friends with somebody in England, and you know, there's $2 million in her account that got stolen. And yeah, it's just a mess. And so the way I present this document is to say, hey, look, Mr. Mrs. Seller or buyer, and every one of our clients needs to sign this, is that wire transfer fraud is a very serious thing. It's important that you understand that if you're going to do a wire transfer, that you take certain precautions, and this details that. And, you know, they sign it, and, you know, it's a liability reduction for us, but we sign it also. Make sure that you're signing this document, they're signing it. It just goes through to say, you know, that, hey, don't trust free Wi-Fi, don't wire money until you confirm wiring instructions via telephone, that where you make the call to the title company. Never trust contact information in unverified emails. Review all emails carefully, and beware last minute instructions, particularly if those contradict earlier instructions. So that's where the big hangup is people infiltrate our, you know, there could be somebody monitoring emails between me and my client for 2 months during a transaction, understand everything about us, and then pose as me saying, hey, I need you to change the wiring instructions. I need to go here instead of there. And that's really how that happens. It's kind of scary.
Yeah.
I don't want to have to be the one to make the phone call to my clients or your clients that says, hey, that $80,000 you were supposed to get, yeah, that's in Russia and Bitcoin now, and that's not going to be a fun conversation to have. So anything we can do to prevent that is paramount. So going back to this loop of everything buyer related, we've covered the purchase agreement itself. You've got the addendum to the purchase agreement up here. We've got a couple of those. This is important simply because anytime you change the contract, we need to have it in writing. We know that. And so this came out of inspections by looks of it. Seller to replace old water heater with new water heater. Seller to reduce sale price by $500 to $159.5. When you're writing these addendums, I want people to be very specific, but not overly what I call lawyerly. You know, we're not attorneys. And so it's important that we say what we need to say, but very specifically, but not get into too much wordsmithing where something can be misconstrued or we can create liability. This is pretty decent. I would say I would want some more actual specifics in here. Seller to replace old water heater with new water heater. Well, when are they going to do it? We should say prior to closing. Who's going to pay for it at seller expense, and who's going to perform that? Well, licensed HVAC professional or licensed plumber are the two people that can install a water heater. So we want to make sure permits are pulled and that it's done properly. So this is a little light on detail. So you think about what is our objective if we're asking for a repair coming out of inspections. Now we know that coming out of inspections, when we write an addendum, that the seller can say no to that, terminate the sale, and put the home back on the market. And so again, we want to have a kind of a counseling session in this type of environment where buyers are at risk of losing a deal because we're asking for a drippy bathroom faucet to be replaced or something. And if you have any questions on this and how to write it the best way, how to be complete with it, just reach out to me and you know, I'll be happy to talk through that with you. But you know, buyers don't have a lot of leverage right now to ask for repairs. And so you may not even write one of these when you get your first offer accepted. All right. So in here, we have the addendum. Looked like there were a couple of addendums. I'm not going to go through the green sheet. That's going to be more of a contract to close. That's our internal form. But that is in there. Now, in the event that you have a deal that falls apart, you have the West Michigan Regional Mutual Release of the Purchase Agreement. And so as a buyer's agent, we're typically collecting the earnest deposit when we write the offer. And our office, if we put spelled out in that purchase agreement that Keller Williams Realty is holding that earnest deposit, we need to decide where that money goes. This came out of inspections, or actually this was a financing issue. And you can see down there, explanation required, financing fell through. Well, that's really all the explanation you need. And so this was a full return of the earnest deposit of $1,000 back to the buyers. Deals fall apart for any reason. I've had everything from like inspections, walk away, financing, buyer remorse or indifference, which we always want to try and prevent and overcome. And I've actually had a client pass away right before closing. So life happens around our business every day, and we need to be prepared for that. But what we're trying to do is protect our buyer's best interests. So if it's a contingency in the purchase agreement, it should be returned. And so we'd ask for that. In this case, financing fell through. Mr. and Mrs. Buyer, here's your $1,000 back. Not every financing falling through is the fault of the lender. Could be the buyer. If they specifically went out and did something to damage their credit, bought a new truck, voluntarily quit their job so they couldn't get a loan. Those things matter in our contracts, and it's not a slam dunk that financing is an automatic out for the buyer to get their earnest deposit back. Inspections typically are, as long as we're submitting this to the listing agent within that 10-day window or whatever is mutually agreed upon in the purchase agreement for inspections. So if we look at this, we're filling in a date, the original purchase agreement date, the address. Again, we always identify the address in our documents. And there is a protection period in here. So let's say the financing falls through, the listing expires, and Beth and Aaron say, geez, we really want that house, and go back directly to the seller 2 months from now. We still have protection on that to get paid a commission. Some of the language has changed on the mutual release. And again, refer back to that video where we talked about the changes on the purchase agreement. And that was published on the Facebook page, but we'll have a company email coming out on that shortly. And we'll continue to do video updates as our forms change on a year-to-year basis. So again, now this is something that does require a broker signature. So you can see here, both Beth and Aaron signed it. Candace was a witness. She sent it over to them. The seller here didn't probably need to sign her name twice, but did. Listing agent signed over here. This does require a broker signature. So you can see here where Keller Williams Grand Rapids East as the selling broker name. And then the authorized designee, whenever you say that, that's me as the managing broker, sign there. And then you also have Beth, who, again, when you don't assign no one, and that's a really bad grammatical way to say that, but it's factual with Dotloop. When you don't assign no one as a signature to a Dotloop, then it can be open-ended and anybody can go in and sign it. And so one of the buyers signed it here, but then you can see here that the broker signed it down here. The signature got added, so we're complete. Once that's complete, once we have a full mutual agreement, then our office will release the earnest deposit back to the buyer. And so there's a couple exceptions to that. If you're like within that 2-day window of an inspection, things fall apart rapidly on your transaction, we're going to require that check clears our account before we turn around and cut a check back to your buyer. Just be aware of that. And then obviously we can get that check in the mail, or you typically pick it up at the office and have it hand delivered by you as the agent. So or they can come into the office and pick it up. Now, it can also be transferred. So once you have a mutual release, we can release that. If you're under contract with somebody else, there's another form that we'll show you here shortly, where you can actually slide that money over to another property without having to tear up a check or issue a check and then recut a check. So they may just say, hey, why don't you hold it? We're going to go buy something else, and we can continue to hold that. So, yeah. Any questions on mutual release at this point? Again, we don't like to dwell on the negative, but it's a reality in our business. And so we have to be prepared on how that works. There's only two ways you can release money. Mutual agreement or court order. And so again, that purchase agreement states that we're holding it. And if the deal falls apart, you either mutually agree to it, which at some point I get to weigh in on it if our company's holding it. And if it's the other broker that's holding it, that broker gets to decide, but we'll look at all the facts. Some are easier than others to decide. And if both parties still don't agree, we just file it with a court. And I've never been to court over earnest deposit. Usually somebody figures out a way, and sometimes it's a split. And sometimes there's just unfortunate circumstances, I mean, it's not an automatic buyer seller breach. It could just be unfortunate circumstances. And so anytime you get into a mutual release scenario and you got questions about who's right, who's wrong, or they're not agreeing to it, come see me. We'll talk through it and help you figure that out. So now, if we're looking for documents to add for our purchase agreement, additionally, the survey waiver is added in there. I don't know if we had a survey done on this particular property. It looks like we did not. Again, survey waivers are pretty common right now. You go and sign a deal on a house in Grand Rapids, and there's 3 chain link fences around the backyard on 3 sides, and you got the curbside and the street. Does it need a survey? Probably not, but for risk reduction on our part, we're going to make the buyer sign something and that says, hey, we advise you that you should probably get a survey on this. And if you don't, it's not really our problem. So when I have that conversation with my buyers, I say, look, probably don't need one here, but you can always get one later, but you can't negotiate on the defects of it if it comes back bad. And then all of a sudden, like the neighbor's garage is on your property, or and they come in handy. I owned a rental property once where the garage was right on the lot line, and I had about a foot on the other side of that garage. And I go down there one day, and the neighbor's building a fence, and he's like tying it right into the corner of my garage. And like, you can't even open your car door if that fence is there. And I had to pull out my survey and show him. I'm like, look, it's got to be over there a couple feet, So they work. There's survey companies. Typically, if we're going to order a survey, we get an estimate. I've been using Netterveld a lot lately. Rosine and Associates has been pretty good over time for us, but there's plenty of survey companies in town too. And again, if you're out of the area, you may need to do a little research on what survey company, or ask around the office if you're down in areas not particular to Grand Rapids. So. All right. The home warranty paperwork is in there. You will require that to be signed as well. Now, this is the full brochure. You can share this with your clients through Dotloop. This explains everything about home warranties. If they're not going to buy one and this one didn't, we need at least one signature from the buyer here to say it was offered. So you're going to need a signature on this document from all buyers, regardless of whether they buy one or not. If they do buy one, then obviously you'd sign them up here. Maybe the seller's paying for it. You'd have to tell the title company that. There's different selections here you can do. I'm not going to get into, you'll have home warranty training at some point with Ray Stark, our rep from there. I'm not going to get into the ins and outs of that, but if you want to go learn about home warranties, that document's a good read and it'll teach you a lot in a hurry about what they cover and what they don't. So, but just know that document's in your buyer template, and that you'll need that at some point. So So let's say I need to add some documents in here. I want to talk a little bit about some of the other documents we use, not on a daily basis. If I go here, I may have something like I uploaded just a file myself. So maybe it's on my hard drive. I can load it here. You can attach it from an email. And then templates are where you find all of our other documents. So in the Dotloop templates, you can see here we've got a couple things. I've got the purchase template, which when you set up your loop, you select either listing or purchase. That's going to import all of those documents. That's what we were just looking at. Now, if I look at the purchase template, I'm going to see all those documents there. There's a couple other ones in here that we can add. Those are optional. I don't know if those automatically get added. There's our addendum, wiring scam we did, disclosure is all there. So I'd copy that in there. We'll look at that in a second. I'll have to look at that because that might be a new one for me. Some of these we just don't use that often. Now, additionally to that, you have your purchase template, but you also have additional purchase documents. So we're going to add some of these other things here. Actually, I'm just going to select them all. We're going to dump those in there. Now you can see we got a lot to look at. It doesn't really take that long because some of them are really rather quick. So, all right, W-9 signed for vendors. So in the event that, this is the Keller Williams W-9. So referral companies, other companies that pay us money, other brokerages, you do a deal with another broker where they're referring you a buyer, you may need to send this. So that's our tax document, not a big deal. Just somebody may request a W-9 for the company and you can just send it over that way. It's quick and easy. Escalation clause addendum. I at first I was opposed to this when it came out, and now I really like it. So it's very succinct, and what I like about it is it does not constitute a counter offer. So if we think about escalation clauses in today's market, where you start out at say 250,000, but you're willing to go to 275 and beat other offers by $1,000, you can write that in the other section. But this really is succinct. And so again, you put the original purchase agreement date in there. You're going to put the address right in here. And then this is your, I will pay above, so I'm putting in my escalator in there, which is your $1,000 or 2,000 or whatever, up to a maximum of 275,000. So now we've got our original offer. This would be signed by the buyer. It goes over with your original offer as part of the document packet to the listing agent. And then the seller signs this if you're the winning bid, says the offer is accepted. We know that a seller can accept, counter offer, or decline any offer. So now what we want to avoid is if you're writing into a purchase agreement a clause for an escalation, that has to define the sale price. Technically, the listing agent could check as written accept, see it in the form of a counter offer, and give you a new price. Well, that might take an hour or two for you to get back to your buyer and get signatures on it. This specifically states that it's not a counter offer, it's just strictly to clarify it. So that would be this checkbox here. Maybe you bait it by, maybe your sale price is 268,000 because the next highest one was 267. We're not going to get into big counter offer day. And so here, if they want to counter, which they can, you don't have to use an escalator and an escalation clause. They may just propose a counter offer. Hey, you said you'd beat everybody by 1,000 up to 275. Our highest offer was 265, but we'd really like you to pay 270. They can counter it that way if they want. I kind of have a rule: pigs get fat and hogs get slaughtered. That's an old Warren Buffett thing, but that's the downside of doing an escalation clause. You've played your hand. You've shown the seller what you're willing to pay for that property. So, but I would highly encourage using this if you're in a buyer agent scenario where you have to write an escalation clause instead of writing it into the purchase agreement. Now, I would still use this language from that document. We ran into a scenario last year where we wrote a cash offer where there were multiple offers that we knew were subject to financing. So we wanted to beat other cash offers. We wanted our cash to work for us. We didn't want to escalate over offers that were subject to financing. We said, we'll beat other cash offers by $2,000. So I took that same language, put it in the other section of the purchase agreement, but specified that we'd beat cash offers. Kind of threw the listing agent for a loop. She's like, what do you mean you don't want to escalate over the? I'm like, look, I want my cash to work for me. So sometimes again, communication with the other agent to explain what your intent is. If you throw them something a little bit different, can be a little bit helpful too. So the Keller Williams addendum to the purchase agreement is, this was a COVID-19 document. We are not requiring this anymore. We left it in there in the event that we get into COVID. The COVID listing agreement addendum, which we'll talk about when we do listing docs, is still required. Now, you may be going back and forth verbally. Maybe the listing agent already wrote you a counter offer. And you didn't accept it, but you're still negotiating verbally, and all you have to do is tighten up that counter offer language. There's a blank 6th page in here. You can do that, so you don't have to go back out and refill out a whole new purchase agreement too. So that's in there. Purchase agreement, I don't know why that's in there twice, but we have one of those. An addendum for temporary occupancy. Again, I like this. The longer I go, the more I hate possession after close, but it's a way of the world right now in our market. I don't see it going away anytime soon. This I wouldn't necessarily send over right when I present the offer. Again, if we're in this environment where offers are scrutinized based on how clean they are, what kind of details are in them. I'm not just shoving this under a seller's nose, and if we're giving them 30 days, but I would like to approach them once we get maybe through inspections or a clear to close, because any possession after close is a leasehold position, and whether there's compensation for it or not. And this goes into a lot more detail of what the seller is responsible for, what the buyer is responsible for during that transition period of closing through that temporary occupancy period. So again, it's pretty self-explanatory. This addendum number, now if you have 1 through 5 because of inspections and well and septic and everything else, you put number 6 in there. But if it's your first addendum, put number 1, the original purchase agreement date in here, the address again. You're going a date, insert time, and include AM or PM. So this would be like a 5 PM on, this is a date specific. So now you've got a concrete date, because again, people start counting on their fingers and toes 30 days, and what seems like 30 days to me is going to be not 30 days to you. And so this specifies a date for move out. Non-refundable fee of, now this could be 0 because that's what everybody's offering these days, and that's fine if that's what it is. Now, if they don't get out on time, there's another line down here. For some reason, it's not fillable. We need to fix that, but there's a per diem in here. I did have a guy, he was buying a foreclosure. I sold his house for him. Wasn't quite ready to move into, and we negotiated, like the contract said, $200 a day, and he was 3 days late, so he left $600 on the counter when he moved out. So it does happen. If there's an amount in there, I think 200 in this market is a bare minimum. People are under a lot of pressure to find a new house if they haven't found it yet. If you put $25 a day in there, that's like a apartment rent,
Yeah.
you know? So make sure it has some teeth and enough motivation to get people out. Again, buyers and sellers need to sign this. This doesn't require a broker or an agent signature, so. West Michigan Regional Cooperation Agreement. So, who here has aspirations to sell something outside of West Michigan? You're licensed in the state of Michigan to sell real estate. I've done deals outside of our board area. And now with our regional MLS, you have to travel quite a ways in order to not find something on our MLS. You have to keep in mind that an MLS is a cooperation of real estate brokers that agree to offer compensation to other agents that bring buyers to their listings. If you go to Mackinac Island to sell a house, you're not guaranteed earning a commission unless you get something like this signed in advance. I say Mackinac Island specifically because thousands, hundreds of thousands, maybe even millions of tourists go to Mackinac Island every year, see a house for sale, call the listing broker and go, yeah, we want to see this, and come back downstate to Grand Rapids, Lansing, or Detroit and call their friendly neighborhood realtor and go, hey, we saw this house on Mackinac Island we want to write an offer on. You go and write it up, send it up there, and the guy's like, I'm not paying you.
Yeah.
I don't blame him. And there's, you know, this stuff has eased a little bit over the years. I remember even as close as Big Rapids 20 years ago, they didn't want to pay you if you were writing up there. Now it's a little bit more cooperative, a little bit farther out. And again, as market conditions ebb and flow in our world, those things change a little bit. But there are, you know, if you're not on our MLS system with that listing, then you're going to want to get this filled out. And again, listing agent, buying agent, both sign it, agree what the compensation is going to be. So now again, it's all in the presentation, right? If I call a broker, set up a showing, and I say, hey, are you willing to work with us on this? And they say, yeah, then it's an easy ask. If I'm sending this along with my offer to a house on Mackinac Island that my friend saw last weekend, it's probably going to get thrown right back in my face. So
Kind of start with that.
yeah. I always, if I'm doing anything outside my home turf area, I'm always calling and asking, hey, are you willing to work with us on this? And you know, be prepared for that broker to ask for a copy of your pocket card and or driver's license or business card to even let you in the house, especially if it's not set up through our MLS. So condominium purchase. This pertains specifically to anything to do with condominium. And so we can add language in our purchase agreements. Obviously, we can use a regular purchase agreement to buy a condominium. There's certain things that we have to realize that go along with that purchase, though, and that's financial burden of the association, bylaws, master deed, Plaza Towers, which you may remember years ago, had a lawsuit against it from its co-owners. The association did, so it was tied up in litigation. Those are, you know, things that need to be known ahead of time. So, and so this is just a further explanation of what the buyer and seller expectations need to be during a condo. Now, I just wrote an offer on a condo last weekend. Honestly, I didn't write this up. I know the other agent, I know the builder. I wrote in there that the buyer has 9 days, which is state law on new condominiums anyway, to review and accept bylaws and master deed. I always add language for finances too. There's a lot of, we ran into an issue last year where we learned that the president of the association was actually holding all the funds for the condo association in his personal bank account. So bank wasn't going to finance that, knowing that John Doe had swift ATM action and could take off to Aruba with the condo's entire funding, but we got it fixed. So, but yeah, not every condo is professionally managed. This is a good protection document. It's the one thing you want to read through and just kind of become familiar with as far as discussing condo sales. I've been a condo dweller my entire life, so it's easy for me to have conversations with my clients about condominiums and some of the pros and cons of them. So there's a document in here about water test. If you're not familiar with PFAS and the hazards of it, get familiar with it. Go to your Access Kent website. There's a lot of detailed information on there. The main hotspots around Grand Rapids would be the Rockford area, Belmont, pertaining to the Wolverine Worldwide issue that is still ongoing. You have well water up there that's contaminated with PFAS, and it's not anything that a regular well and septic test is going to test for. It's easily fixed, but not necessarily cheap. And so one of those things that you want to talk to your buyers about. Now, lesser known is the Thornapple River neighborhood just over beyond the airport, where there's runoff from the airport runways, de-icing chemicals that have contaminated some wells over there, and they're putting city water in. I've got more information on that, but those are the two hot spots. But again, advise your buyers, get to know this is kind of stuff you have to pay attention to and understand what's going on with property values. I actually had to do a deposition last year regarding a sale up in Rockford. We did because it was named in a class action lawsuit unbeknownst to us against Wolverine and the loss of property values. And we had a hard time. Well, the plaintiff's attorney had a very hard time making a case that property values were down, especially after city water had gone through the neighborhood. So it was a pretty short conversation, but these things come up, and as it happens, we're going to keep you advised on stuff if things change in the marketplace. So this we've already seen. This is your blank addendum to the purchase agreement. And let's see, what else do we have in here? Addendum, agent is buyer. Well, on occasion, we all buy our own real estate. So now, bare minimum, I don't really use this a lot. Bare minimum, I would put in that in the purchase agreement, we know that state law, buyer is a licensed real estate agent, or if you have a spouse or immediate family member, you should at least be disclosing that you're working on behalf of that person as an agent. This gets real specific. Like, I'm not filling this out. If I'm buying a piece of investment property, I'm not telling the seller what I'm going to use it for. They can pound salt, but that's just my 2 cents. But there is a further disclosure statement. But again, bare minimum in your purchase agreement, if you're buying something on your own, make sure you're disclosing, or selling too, that you're a licensed agent, state of Michigan. So
if like, I mean, obviously I understand that for myself, but then if I would help like a family member, you said
immediate family member is, yeah, just buyer's agent is family member of the buyer or something to that extent is fine. So yeah. We have another document in here, the amendment to the buyer contract. All these autofill, you can autofill them if you want. So this looks very familiar to the listing agreement because it's also the same form we use to change prices on listings. But down here in this section, you can expire a buyer agency contract early. So let's say with these people, we had it filled out in October, and March 31st rolls around, and that would be the date that it would normally expire on. We'd fill that in here. But let's say we just want to fire this buyer. Like, maybe they're, these people couldn't get financing. I don't want to be bound to go out and show them houses. Mm-hmm. They can't buy anything. Maybe it's time to terminate that contract. So I may fill that out. Maybe they're unhappy with you. If that's the case, come talk to me. I want to find out why, see if we're missing something. But we can expire a buyer agency contract. It can also be extended. So, you sometimes you run into a client that may just be averse to signing something, and you may have to go that route of, hey, Mr. and Mrs. Buyer, let's sign this for 2 weeks, see how things go. And if you like working with me, then we can extend this or sign a new one. And so you could extend it this way. This does need a broker signature on it. So you can see here, that would just be a send over to me to my broker email. We'll throw a signature on it as well. You can sign there as a witness. Internet's moving slow today, guys. All right, short sale addendum. This should be written on parchment paper for as relevant as it is in today's market, but less than 15 years ago, we did a lot of short sales. So again, if you get into a short sale scenario in this market, I'd be highly surprised, very surprised on that. But short sales strictly defined as somebody that owes more on their house than what you can get for it on the open market. And so there's some, it's subject to bank approval, third-party approval. There's a lot of things that go into it. If you get into this scenario, come see me. I doubt we're going to have these much at all in the next 5 years as prices continue to go up, but you never know. We did one within the past 5 years. I was really surprised. This guy bought a house on 44th Street and did nothing. Like, he moved in and just rode it hard and put it away wet. It's like an old Maggie racehorse, man. It was just bad. Broken windows and just trashed carpet. And it was just, guy played drums and smoked a lot of weed. So yes, I am recording this and that's on record, but I won't give you the address or name. So anytime you want to hear real estate stories, come see me. I always have good ones. So dual agency. So in our agency disclosure form, in our buyer agency form, in our listing contract, we always discuss about the possibility of dual agency. Now, we know we're designated agents. So the only time dual agency occurs is if it's your listing and it's your buyer under buyer agency contract. Now, again, if somebody calls on a sign, they want to write an offer on my listing, I'm not signing them up to buyer agency. I'm not entering into dual agency with them. But if it's a buyer that I already have and I take them to one of my listings and I say, hey, you want to write an offer, then we approach this dual agency. And so what this is Keller Williams specific. This is going to say, hey, look, Mr. Seller, Mrs. Buyer, Ms. Buyer, we do both of the sides of the transaction all the time. As a dual agent, though, there's certain things that I can't disclose, like the seller's willingness to accept a lower price or the buyer's willingness to pay a higher price. We act as an intermediary. So there's going to be a little bit of question and answer, like, hey, what are you willing to pay for this? And we'll write that in and present it. And so both buyer and seller need to sign off on this. And again, this is kind of in the delivery. I kind of start out with that conversation of like, hey, we do both sides of the deal a lot, doesn't prohibit us from needing to disclose to the buyer defects I know about the house, conditions of the real estate market. I'm still going to work in that manner to help you get the home, but there's just certain confidential things between the buyer and seller that I can't disclose. At that point, if somebody's not comfortable with it, you can always refer that buyer to another agent within our company or outside of our company, earn a referral fee, split the deal with them, whatever works. And I always just kind of approach it from a customer satisfaction. Like, dual agency is risky. And because one slip up of revealing confidential information, and you can be held liable for that. And we don't want that. Again, it's not an easy thing to do, but it can be done. I prefer, like I said, if somebody calls and just says, hey, I saw your sign in the yard, I want to go write an offer on it, that we don't sign them up to buyer agency. Now, that doesn't mean if they say no to that house, or you can't get an offer accepted on that house, that you can't then sign them up to buyer agency and be their buyer's agent and go sell them something else too. So just keep that in mind.
That was actually how I bought my first house. I called them the sign, entered into dual agency with the realtor who had it,
Mhm.
But yeah, he was super like, yeah, I can't really tell you, I lowballed the shit out of it anyway, so it didn't really matter, but
Well, and I'm guessing that was some time ago, so.
yeah, right.
There's
Couple
no
years ago.
low ball goes on parchment, just like our short sale addendum these days. So, show and sell agreement. So this would be, let's say you stumble across a for sale by owner with your buyer and you still want to get paid. This has a lot of blanks in it. Pretty easy to fill out though. Obviously date here. Seller's name goes here, and then we're obviously identified as the broker as Keller Williams Realty of Grand Rapids. Seller owns, again, you're putting in address information, city of Kentwood, Kent County, zip code to identify that and the permanent parcel number, the tax ID number to identify the property. And what this does is it gives you the non-exclusive right to sell that property for a period of maybe 2 weeks, a month, or whatever, and says, hey, I'm going to bring you a buyer. Maybe they have a price on it, maybe they don't at that point. You can say put TBD in there if you have to. Terms, what they're willing to accept, could be cash, mortgage, these are radio buttons. Other terms and conditions. I wouldn't get too wordy on this. I think it's pretty simple. You put your commission percent in here. If you can get 6%, great. 3% aside, at least you're representing. I will tell you this, for sale by owners are more work. I would shoot for 4 or 5. If you take 3, I've done it for 2.5. And so I don't argue. I just, say, hey, look, if at the end of the day, they're willing to work with a broker on this, they're willing to pay you a commission, get the deal done and keep moving forward. There is a protection period in here. Again, you can put a number in there like 3 or 6 months or something to protect you in case the buyer turns around behind your back and goes and buys it too. So parties acknowledge and agree there's no agency relationship between the broker and the seller. Again, this goes on to conveyance of the deed, terms that are in the purchase agreement, non-discrimination clause in there. So pretty simple form, but necessary if you want to get paid on writing on a for sale by owner.
So that would be if I brought a buyer to a for sale by owner?
Correct.
Gotcha.
Yep.
Okay.
And you can also use that as a pocket listing document. Like maybe somebody that says, hey, I don't want to list my house, but if you bring me a buyer, I'll pay you, a commission. And you could get that for 6%, network it through our office and find a buyer and bring them there, or even another agent that or go find your own buyer for it. So you can use it as a pocket listing document too to make sure you get paid. So that'll work. Foreclosure and short sale disclosure, again, not very prevalent these days, but in there if you need it. This is just kind of an understanding of how foreclosures work, that there's bank addendums, decisions that are made by third parties that are outside the control of us as the broker, where the closing will occur, how much you're going to pay for that closing. It's just what I say in a nutshell with foreclosures is the bank's going to tell you when to jump, and you should probably ask how high on the way up. And so it's their rules, not yours. You're not going to change bank addendums. You're not going to change anything that they stipulate in the purchase agreement. Just understand that you might be getting a better deal than what you could on the open market with an existing house. So same thing with short sales, just goes in to explain what short sales are. I think it's a good form if you get into that, but buyers should sign it so they have an understanding of what they're getting into as well. But if you have a buyer in this market that says, hey, I want to buy foreclosures, you might as well go find another buyer. Yeah. So home warranty, again, this is that final page only. Like if you just need that waiver signed and you don't want to send the whole brochure over, you can just pop that in there and get a signature on it as well. Mutual release we covered already. Survey waiver we covered. Now lead paint booklet. We used to have drawers full of these, in your standard lead-based paint form, you're going to have a checkbox on there. If the home was built before 1978, there's 3 checkboxes on there. One says, have they had an opportunity to inspect it or waive the inspection? Have they received any documentation? And have they received the federally published Protect Your Family from Lead in Your Home book? Well, that's what this is. You can share that via Dotloop. So any home built before 1978, you got to go into that other documents file, download this in, share it via Dotloop so people can read how to protect themselves from lead paint. So federal requirement, the farther we get away from 1978, the less of an issue it becomes, but it's still, lead poisoning is actually still a real thing in certain parts of the city where homes aren't as well maintained, or you have, landlords that aren't taking care of stuff on a regular basis too. So agent referral form. This is, I think, in both the listing and the buyer docs, but if you have a buyer or a seller going outside the area, you can refer this to any broker, either within the Keller Williams system or outside. Just need some detailed information. Both brokers need to sign it. What you do want to do is, typically we're going to put 25% in there as a referral fee down here. That's kind of standard. If you can get 30, great. But make sure that that's filled out. Both brokers sign it, both agents sign it. Contact information, pretty self-explanatory. The data field you got to fill out in there. And not everything needs to be filled out, but you should at least be giving the other agent and broker some contact information at the bare minimum. So. And then this is that EMD transfer form. So if you do have a sale that falls through, you can go in there and assign that to another property. Buyer does need to sign it. Obviously, it's their money, so we want to make sure that they're authorizing the transfer of it, not just us, but and then the agent can sign it. So if you've got another address, and again, if we have mutual release and they just say to hang on to it, we can hold it, without an address, but eventually you're going to need that filled out once you get something else under contract. So. Grand Rapids title payoff. I don't know why this is in the buyer docs. That should be in the listing docs. We don't need that. Now, title order form. We're going to go into title work a little bit more in a different session, but title insurance, contrary to the abstract that we now get, we get a report of the general condition of the title on that. Are there liens on it? Are there things that encumber the title? Are there defects that we need to know about? So in-house, we order from Grand Rapids Title. Again, if your buyer client wants to get their title work elsewhere, they're legally can do that. We recommend Grand Rapids Title. We own part of the company here. We have to disclose that, but there's a checklist here of everything you need to turn into the title company. And you can share that by adding GR Title. I think it's right on here, office@grtitleco.com. That email address, you can add them as a Dotloop and just share everything right out of your loop into their office. And so again, this needs to be filled out completely. You should know at least your selling agent commission on that. And our broker fee for my team, again, it's $395. Put that in there so they know to put that on the closing statement. Again, if you're ordering seller side, you're going to know. And again, we've got transaction coordinators on our team that are going to do this, but in the event, somebody's out, you need to order title, where you still need to know where to get this from. So. Okay. Handicap signed order form, not really a buyer doc. My team, your signs are taken care of. We got ordering for that already if you need them. Showing certification and release. We added that into the loop, didn't we? Yeah, that was that COVID-19 document. Don't really need to be too aware of that right now. I would still be having conversations with my buyers about that. again, I've been doing this a while, and I try to be everything to everybody, I guess is the best way to put it. And this COVID environment that we're in is a tough environment because there's a lot of different thoughts and beliefs on it. I've got a good client. We went out and looked at something one day, and I didn't wear a mask. We were kind of past that point of wearing masks in the houses. And, one point they wanted us, I think, to wear hazmat suits and gloves and everything. And that's fine. It's a dangerous thing and we need to be prepared for it. That went away, but my client was still wearing masks during showings. And then he made a comment of like, hey, because we had an overlapping showing, that guy didn't have a mask on. I was like, well, shit, I was with you the other day. I didn't have a mask on either. So it's just, mental note, be aware of what your client's needs are and be prepared for that. Even if, the seller isn't requiring masks in the house or sanitizer, whatever, be prepared to work with buyers that may want you to have that. So, let's see here. We kind of slipped away from our add documents. Oh, we added those. Okay, never mind. So that takes us down here. I think we're pretty good. Like I said, we're going to get into title work at another session. We're doing these weekly now. We're recording the videos. I'm going to publish the videos because we're doing that on a couple different platforms. But those will be coming. If you want to review any of these, you'll be able to go back and kind of review them. And if I'm not around to help with a specific thing on a purchase agreement, then you'll at least know how to fill out forms and stuff. So does anybody have any questions on anything pertaining to the rest of the buyer documents?
I don't think so. It's good to know.
Yeah, a little quick tip here. If you're outside of a loop, like let's say you just got to go get a lead paint form filled out by somebody. Reason I'm doing that is because we didn't look at it from the buyer side. We will on that, but lead-based paint disclosure. If I just got to run and get that signed and somebody's got a pen in their hand instead of their phone to do an email, you can just go into the template outside of the loop and either download it or print it too. So there's access there. This again, if it's built after 1978, sellers should just sign up here. That's all you need on it. But if it's built prior to 1978, then this all needs to be filled out down to here by the seller. This would be, and again, we'll go through this as the listing doc on that end. This should be the listing agent's signature. This is what you need filled out by your buyer here. So they would initial, you check box, sign it. I can't, it's in the template. It's not in the loop.
Bottom part is if it is older than.
Yeah, anything older than 1978, this would need to be signed by your buyer.
Otherwise, everyone gets this. If it's newer, they just sign that top line.
Yep.
Okay.
Yep. So
if a client wanted physical copy to sign, we could just print everything out of here.
yeah.
And these signature things would pop up in the print.
Yeah, if you, I can show you here. If I just do a download of it.
Oh, okay, I gotcha.
And then I open it. It opens as a PDF and it's fairly blank. So.
Okay.
Any other questions on buyer docs? We got this in actually a fair amount of time. The purchase agreement was what takes so long, and that was our last session. But like I said, next week I got to figure out what topic we're going to do. I got a list of stuff to go through with you guys, and we'll get after it and probably do listing docs next week too. So, but
Sweet.
Normally you're going to be buyer heavy your first couple of years in the business, and so buyer docs are the ones you have to be concerned with first, unless of course you're Sierra, who I think is still on here with us. Her first deal came as a
Yes, I'm here.
as a listing, very rapid fire. So
Yeah, I actually just got another one today.
good for you.
Yeah. Yep. And then another one beginning of April. So
Awesome.
yeah.
Listings are where it's at right now, so keep getting listings. They will sell. So all right, if nobody has any other questions, I'm going to log off and call it a day. Otherwise, you know how to get a hold of me if you have any questions on this stuff. So thanks for coming in, and we will talk to everybody soon. Okay.
All right, see you guys.
Thank you.
Bye.
Bye-bye.